Patient Safety and Quality Clinical Excellence Queensland has developed a podcast series for Queensland Health staff and Hospital and Health Board members to hear from guest speakers on topics relevant to safety and quality in short bite-sized segments. All episodes are recorded on the lands of the Yagara and Turrbal people. We respectfully acknowledge them as the traditional custodians of Meanjin and pay respects to the elders past, present and emerging.
Hello and welcome to another episode in our Patient Safety and Quality podcast series. In this episode, we'll be providing an overview of clinical reviews and health service investigations commissioned under the Hospital and Health Boards Act. We'll discuss what these processes are, when they're used and why they're important to safety and quality. I'm Megan Window, a Director with Patient Safety and Quality, which is part of Clinical Excellence Queensland. Joining me today is Kirstine Baker, Executive Director, Patient Safety and Quality, Clinical Excellence Queensland, and someone with over 2 decades of experience in patient safety and quality, including in relation to matters around clinical reviews and health service investigations. Hi Kirstine, welcome and thank you so much for joining us today.
Hi Megan, it's a pleasure to be here.
Kirstine, I just wanted to note at the outset that the vast majority of care delivered in hospitals and health services in Queensland is very safe and effective. However, we all know that occasionally things may not always proceed as expected, despite the excellent skills and best intentions of our staff. When this happens, it's distressing for patients, their loved ones and staff, particularly when the consequences are severe. So Kirstine, can you tell us how clinical reviews and health service investigations under the Hospital and Health Boards Act fit into safety and quality?
Yeah, firstly, it's really important to understand that the intent of any review process is to identify what happened, why it happened, and any areas for improvement. This just ensures that we learn from these events to prevent future harm and to improve the care provided to our community. Clinical reviews and health service investigations are just a couple of the many review processes that can be used.
Great, thank you. Can you help set the scene and explain what a clinical review is?
Yeah, look, so for our discussion today, when I refer to a clinical review, I'm referring to those reviews that are commissioned under Part 6 of the Hospital and Health Boards Act. The purpose of a clinical review is to provide expert clinical advice. The expert clinical advice, it may include assessing, evaluating of the quality of patient care, clinical outcomes and the performance of healthcare providers. The reviewer might look at one case or they may even look at several cases.
Where do health service investigations fit into this? What are they?
Yeah, so just to be clear again, these are investigations that are commissioned under Part 9 of the Hospital and Health Boards Act. So the purpose of these investigations is to investigate and report on any matters relating to the management, administration or delivery of public sector health services, including employment matters.
So correct me if this isn't quite right, but my understanding is that these processes are generally used to enable an independent and external review or investigation to be undertaken following a clinical incident or incidents.
Yeah, that's right.
Great. I'm actually curious to understand when you would choose to use a clinical review.
Yeah, so a clinical review is generally an option when expert clinical advice is needed. So this might arise where potential clinical issues or even issues regarding patient safety have been identified. So, for example, there might be a high number of complications post-surgery arising from the same department, or all of the complications may be related to one practitioner.
Okay, so the focus is very much on obtaining expert clinical advice. So what about a health service investigation? When would that be used?
Yeah, so a health service investigation is an option where issues are more related to the clinical governance. So, for example, there's a series of complaints about patient and staff safety being escalated. Perhaps these complaints may not have been addressed.
Okay. I've also sometimes heard the term privileged or protected when people refer to Part 6 clinical reviews or when they talk about them. Can you tell us a little bit more about protections for a clinical review or a clinical review report?
Sure. The clinical review report is protected under the Act, and that means that the report is not admissible in any civil or criminal proceedings or even a proceeding under the health regulation national law. The protections provided to the report is helpful because it encourages openness and transparency during the review process.
And do these protections extend to health service investigations?
No, a health service investigation report does not have the same protections as a clinical review report.
Oh, that's interesting. Is there a particular reason why those protections would only apply to a clinical review report?
Yeah, the protection ensures that the purpose of a clinical review can be met, which includes assessing and evaluating the quality of patient care, clinical outcomes, and the performance of healthcare providers. So it also ensures a restorative, just culture can be upheld, with the review focusing on improving safety and quality rather than allocating blame. It also enables individuals who may be involved in the review to speak openly about what may have occurred, and it protects highly sensitive patient information, which is reviewed as part of these processes.
I'm curious, is there ever a situation where you might decide to use both a clinical review and a health service investigation, or are they always separate?
Yeah, there absolutely is. So, in the situation, the clinical reviews would be appointed to undertake the clinical review, and the review would provide expert clinical advice, which would then inform the health service investigation. This would usually occur where there are concerns regarding the clinical care provided, and generally, there are potential clinical governance matters that are linked to these clinical care concerns.
So, how does that actually work in practice? Like, what order are things undertaken when you have both a clinical review and a investigation that's been commissioned?
So the clinical review is undertaken first, and it's a requirement under the Act that the report from the clinical review is provided to the health service investigators for them to consider and help inform the investigators' report.
Okay. So we were talking before about the protections provided to clinical review reports under the Act. Do the same protections apply where you have a clinical review report that's actually being used for a health service investigation in the situation that you've just spoken about?
Yeah, in this instance, there's no protection provided under the Act for a clinical review that has been commenced to inform a health service investigation. So, really, protections only apply to a clinical review that's a standalone.
Okay. And I guess that makes sense because if the clinical reviewer is then providing the report to the health service investigation, it's already being, I guess, distributed a little
Yeah,
bit more broadly than it ordinarily would.
yeah, that's right. Yeah.
Can anyone appoint a clinical reviewer or health service investigator? And how many reviewers or investigators are able to be appointed at any given time?
No, so it's really just the Director General of the Queensland Health and the Health Service Chief Executives. They're the only office holders that are able to appoint a person as a clinical reviewer or a health service investigator. The number of reviewers or investigators appointed are really determined by the expertise needed to examine the issue in question. And the numbers can actually range. It could be one investigator or reviewer, or it could be quite a number of them, depending on the extent of the review and the level of expertise required.
In your experience in this space, is there almost a default or standard number that you've come across generally, or is it really very variable?
It's variable. Yeah, it really depends on the extent of the review that's required and the expertise needed.
Okay. And what about minimum requirements to be appointed as a reviewer or investigator?
Yeah, so legislatively, there is a requirement that the person must be qualified and have the necessary experience or expertise.
And so, what does that look like in practice? So, what types of things would you be expecting to see if you're a clinical reviewer being appointed or an investigator in terms of qualifications or skills?
Yeah, so in practice for a clinical reviewer, they would need to have the clinical expertise in the relevant area and the ability to examine the care to see if it meets the expected standards. For health service investigations, an investigator would really need to have experience in the delivery of the relevant type of healthcare and also be able to identify what processes and procedures should have been followed so that they can really identify any gaps in the system. So that really includes how employees handled the situation.
Okay. So I'm curious to find out about what powers reviewers and investigators have under the Act. Are there any key or core ones that you think might be worth mentioning?
Yeah, there's actually quite a few powers under the Act. These really enable the reviewers and the investigators to undertake full and open processes, including sourcing all of the relevant information. So, for example, reviewers and investigators, they're actually empowered to enter a public facility at any time it's open for business or otherwise open for entry.
Does the Act impose any other obligations on HHS employees during reviews or investigations?
Yes, it does actually, and it's really quite useful because it actually requires that employees must not give false or misleading information, and they must not obstruct a reviewer or investigator in actually exercising this power.
And I guess that's all directed to ensuring that the reviewer or investigator can actually get on with the job they need to get on with and get the information that they need.
Yeah, and have the accurate information at their hands.
If during a clinical review, some of the information that the reviewer collects suggests that there might be deliberate acts on the part of a clinician, what happens?
Yeah, look, that's a really good question. It doesn't happen often, but sometimes if it does happen, that in a course of reviewing clinical records or other documents and interviewing witnesses, certain information results in a reviewer forming a reasonable belief that a matter under review involves a blameworthy act. So a blameworthy act, which I'm guessing you'll probably be asking me what is a blameworthy act, but a blameworthy act, it's either an intentionally unsafe act, deliberate patient abuse, or it's conduct that constitutes a criminal offence.
So really the higher end of the spectrum in terms of intent and deliberateness on the part of the practitioner.
Yeah, that's right.
And so what happens to the review if a reviewer actually finds or thinks that there might be a blameworthy act?
Yeah, so in that situation, a reviewer is required under the Act to stop the review and then give the written notice to the appointer that states the review has been stopped and the reasons the reviewer formed the reasonable belief.
Do the same provisions or requirements apply to health service investigations?
No, the requirement's really just for the clinical review. So the requirement is to stop a clinical review for that blameworthy act.
Kirstine, I understand that there are also legislative requirements to notify the Health Ombudsman if clinical reviewers or health service investigators become aware of notifiable conduct. Can you talk a little bit more about notifiable conduct?
Yeah, look, I think this is a really good question because people do get confused a little bit between blameworthy acts and notifiable conduct. And notifiable conduct, it's a little bit broader. So notifiable conduct is when a registered health practitioner has either practiced while intoxicated by alcohol or drugs, or they're engaged in a sexual misconduct in connection with the practice of their profession, or they've placed the public at risk of substantial harm in the course of their practice due to impairment, or the most common out of the four is around where they've placed the public at risk of harm due to a significant departure from acceptable professional standards in practicing the profession.
It's a mouthful.
It is a little bit, yeah.
So if you're a reviewer or a health service investigator and you identify notifiable conduct, what happens next?
Yeah, so if you're a registered health practitioner or an employer, you must notify OHO as soon as possible if they reasonably believe a health practitioner has demonstrated notifiable conduct.
Okay, great. Thank you. So if we move on to the mechanics around health service investigations and reviews, if the Director General or a health service chief executive has appointed a reviewer or investigator, what happens when the clinical review or investigation is actually completed?
Yeah, so under the Act, the reviewers and investigators must provide a report to the appointer for each review or investigation. So a review report may make a recommendation in which patient safety, care provision and quality of services can be improved. And a health service investigation report, it may make recommendations in which administration or delivery of services, including employment matters, can be improved.
So what happens in the case of a clinical review that's been commenced to actually inform or assist with a health service investigation?
Yeah, another really good question, Megan. There are slight differences in this situation. So Where a clinical review has been commenced to inform a health service investigation, the final clinical review report, it must be provided to the health service investigator, who then considers it for the purposes of the investigation report. There's also a requirement that the investigator attaches a copy of the clinical review report to the health service investigation report. Then the health service investigation report is then provided to the appointer.
And you can probably guess what my next question might be. So let's assume that the Director General and or the Health Service Chief Executive has the final report from the reviewer or the investigator. What happens next?
Yeah, so after considering the report, the Director General or the Health Service Chief Executive may take the action they consider appropriate in relation to the matters identified in the report. So this might include requesting that certain stakeholders undertake actions to address the relevant recommendations to them. So even when a health service chief executive has commissioned a review or an investigation, the Director General can request a copy and must be given the report. So the Director General can take action in relation to this report if they consider it's appropriate.
Okay, so in practice, would it be fair to say that where there are recommendations that require HHS actions, HHSs should take steps to ensure that these are actioned and implemented where appropriate, irrespective of directions from Director Generals or others?
Yeah, that's right. Yep.
What about actually publishing a report? So it's clear from our conversation that clinical review reports that are commissioned alone can't be published given the protections under the Act. But what about health service investigation reports?
Yeah, so health service investigation reports, you may have a full report that's published, or you may have part of a report such as an executive summary or recommendations, and the Director General has that power to be able to, and the health service chief executive has that power to be able to consider whether that's an appropriate action. Importantly, with those reports, when they are published, it's really important that identifying information is redacted.
Yeah, that protects privacy and sensitive health information.
Yeah, that's right. Yeah.
So, Kirstine, are there circumstances where the publication of either part of or the entire health service investigation report would not be possible or appropriate?
Yeah, there are a couple actually. When the health service investigation relates to an employment matter or may become an employment matter, that would be one. Another might be it might not be in the public interest to actually report the information. So, for example, where there's potential for detrimental outcomes for the family involved in the process of reporting that information. Another one is if the investigation actually relates to a matter that is subject to an ongoing or potential criminal investigation or other legal proceeding.
Okay. So if the Director General or Health Service Chief Executive does decide it's appropriate to publish the report or parts of it, where does this actually happen?
So there's a Queensland Health website called Reviews and Investigations, which is where any published information about investigations commissioned by the Director General are published. So essentially just jump onto Google, type in Queensland Health Review and Investigations, and you'd be able to find that. Health services may also publish reports on their own website. And I've also mentioned before that often a decision is made to publish only part of a report.
And just a reminder as well that Part 6 clinical reviews are not able to be published unless commissioned to provide clinical input for a health service investigation.
Yeah, that's right. Yeah.
So our conversation today has mainly been about the purpose and mechanics of clinical reviews and health service investigations. It might be helpful for our Queensland Hospital and Health Board members to, get some idea about some of the things they should be thinking about if they become aware of a Part 6 clinical review or health service investigation under Part 9, which arises from an incident in one of their hospital and health service facilities. Are you able to give us some key points that might assist?
Yeah, so some of the things to consider as a board member might include, firstly, whether all necessary immediate steps have been taken by the health service just to ensure the safety of staff and also consumers. Secondly, you might also make sure that all the necessary people have been informed. So this would include the families and the staff where relevant, the Department of Health, and potentially other external entities such as the coroner and the health ombudsman. It may also include messaging to the community where harm has potentially occurred to a number of people. And finally, it's really important for the board to actually seek some agreement on when the board will be provided with updates.
Okay, that's helpful. What about when the review or investigation is actually completed? What does the board need to know or consider at that stage of the process?
Yeah, some of those key things would include confirming if the health service has an action plan that addresses really all of the recommendations robustly and in a timely way. The second thing would be around whether the findings have been shared where appropriate with those who have been impacted and whether appropriate communication has occurred with staff and the impacted services. And similar to the question before, really ensuring that the board again has an agreed timeframe on when they will be provided with updates now on the progress of the recommendations.
So that enables the board to monitor and keep an eye on how things are progressing overall following these types of reviews and investigations.
Yeah, that's right, because that's really their legislative responsibility to be doing those things.
Great. I guess we've covered a lot today. I'm just wondering if you have any final comments that you'd like to make in relation to these types of reviews and investigations.
Yeah, thanks, Megan. Look, I think it's really important to understand that ultimately the clinical reviews and health service investigations, they're really an opportunity for improvement and potentially change within a health service and sometimes even more broadly across the system.
Yeah, that's helpful as well. I think to keep in mind that all of these processes are about improvement and potential change ultimately. That's been really helpful. Thank you so much, Kirstine. I really appreciate your time today. You've helped to shed some light on the purpose of these types of reviews and investigations, and they are important methods leading to improvements in safety and quality.
Yeah, thanks, Megan. Look, I've really enjoyed our conversation today.
Further information regarding health service investigations and clinical reviews, including publicly released investigations, can be found online at both the Queensland Health website and QuEPS. Thanks for listening.